Speaker.
Before I call a member, I just want to draw the minister's attention and the attention of the government whips to Speaker's Ruling 53.4, which involves a report of the Standing Orders Committee as to the reading of speeches. There is normally a dispensation given to ministers in the early stages of bills, and especially where there are technical matters in bills. Now, I realise the minister is not the minister in whose name the bill is, but I think it is incumbent on the government to have a minister at least familiar enough with the material that they're presenting to the House that they can make a speech without just reading it out, because otherwise it becomes a pro forma exercise, and I think it doesn't show due respect to the House. Well, it wasn't really a point of order, but the member might like to make
point of order, yeah. So, Mr Speaker, I will take that up with our whip. So I noticed the clerk handing you a note there to that effect, so I do wonder where that direction did come from. But I take your point, I think it is a valid one.
Yeah. Well, actually, one, of course, never refers to the clerk, and when one is referring to a ruling, and I will say, I probably shouldn't respond to the member in that the clerk handed me no note.
Oh, well, whatever.
Phil Twyford.
I think we know what went on.
Thank you, Mr Speaker. I was just listening to the Minister read his speech earlier, and it struck me that this bill is a rather poignant, I was going to say postscript, but it's not really a postscript because, as we all know, the Leaky Homes catastrophe is not over, it continues on. But it is poignant nevertheless, and this bill, the problem that it seeks to address, how this, the story of this bill's kind of development through the House really says a lot about major intractable problems in one of our country's most important industries. And I believe the failure and neglect of this national-led government to take those problems seriously and do anything about them. The construction industry is one of the most important industries in our country. It's responsible for 1 in 12 jobs. It generates 8% of our national wealth, and it comprises 10% of all businesses in New Zealand. It's a huge employer, it's a huge generator of wealth, and more importantly than that, it creates the built environment. It creates the very places where we live and work and play. And as anybody who has followed the horrendous saga of the Leaky Homes disaster knows, the poor quality of building in this country has been a blight on the lives of so many people, and it is a drag on our country's prosperity. The construction industry is incredibly important for the reasons I spelled out, sir, but it is beset by low productivity. It is racked by a boom and bust cycle that regularly cleans out the skilled workers who are so important in that industry. And those are some of the core factors behind the Leaky Homes crisis that this bill seeks to address. And this government, and in fact successive governments, have struggled to get the regulatory framework right in the building and construction industry and find the right balance between protecting consumers, holding accountable the construction companies and all the other construction trades and professions. And worst of all, the industry has subjected New Zealanders to a problem that PricewaterhouseCoopers estimated has cost the country in the region of $22 billion. And that is the Leaky Homes catastrophe. We support this bill, and we have supported it all the way through. And I'll talk a little bit more about the three kind of key measures in the bill. But the main point that I want to make, Mr. Speaker, is that this bill is symptomatic of so much that this government does. This government has made tinkering into an art form. When there are so many pressing problems and challenges that the government should be addressing, and I'll talk about some of those, it seems to focus its attention and the resources of this House on small measures that barely scratch the surface of the problems that the government should be looking at. What does this bill do? Only a few months out from the expiry of the Act, only a few months out, this bill basically gives some clarity and seeks to refine some of the provisions of the Weathertight Homes Resolution Services Act, and it will have the effect of extending the provisions of the funding assistance package, which is a scheme which gives homeowners who are affected by weathertightness problems, it gives them access to the funding provisions that would see the government and council stump up with 25% each of the repair bill. So it gives them an alternative to going through expensive litigation. But the effect of this bill is to extend that benefit to approximately, according to government officials, approximately 70 homeowners. 70 homeowners. And yet what we know from PricewaterhouseCoopers is that there are about 42,000 homes in New Zealand affected by weather tightness problems. Approximately 80,000 New Zealanders affected. And in stark contrast to Maurice Williamson when he was the Minister of Building and Construction, who with great fanfare announced what he said was a $1 billion funding initiative. A $1 billion initiative. Well, actually, what we do know is that up until a year ago, which I think is the most recent figures that are publicly available, there have only been 1,147 claims made under this package. And yet there are more than 42,000 homes affected by weather tightness problems. So this is tinkering at the margins, and it is so typical of this government. So there are three key things that I think we need to mention. The first is that the bill aims to remove doubt regarding the validity of a couple of clauses in the Gazette notice published pursuant to the main Act, sir. And these clauses cover claimants who had applied for adjudication under the Act or have applied for or are involved in other civil proceedings. And basically it brings those provisions that were included in the Gazette, brings them into the Act for the purposes of removing any uncertainty. The second thing that the bill does is that it responds to the Osborne case, Osborne versus Auckland Council, which went to the Supreme Court. It's all about the use of the term built and the definition of built in regard to the 10-year limitation that's built into this Act. 10 years after the Act said house was built, and that was interpreted as when, well, it was unclear as to what it meant, but the courts had until then interpreted it as, what the Osborne case did was ruled that the definition of built was when the code compliance certificate was issued, and that ruling allowed a significant number of other claimants to come under the Act. And the third thing is about widening the definition of the qualifying claimant, which again is about claimants who are actively progressing claims but haven't yet become eligible to be covered by the funding assistance package. This basically just creates a clearer line and a clearer definition about their coverage. As I said, sir, this bill will extend the benefits of this legislation to another 70 claimants. It is tinkering at the margins of this problem, and it is so typical of a government that has neglected and ignored a number of problems in this vital industry that have basically, I think, caused a drag on the country's growth and prosperity, and have created a situation where ordinary Kiwis are paying the price for this and are being ripped off. So the leaky homes problem is the most well-known example, but we still see an epidemic of shoddy building, and the Auckland Council recently said that they were failing between 25 and 40% of building consent applications because of shoddy building. And the reason for that is that this government has failed to invest in skills in the building and construction industry. They've imported large numbers of migrant tradespeople to fill the skills gaps. Those skills gaps are endemic to this industry, and they are one of the core factors behind the leaky buildings and weather tightness problems. And yet they continue today. And Paula Bennett, who was then the Minister of Local Government, with her loopy rules reduction task force.
Okay, I am now going to interrupt the member and to remind him that we are doing a third reading debate, which is a debate on the bill as it has emerged from the Select Committee. It's relatively tight. There are plenty of rulings on it, around pages 136 and 137 of Speaker's rulings. While a member has generally been quite good, having been fairly tight on the Minister, I'm now reminding the senior opposition member that he should stay within the rules.
Thank you, Mr. Speaker. The argument that I was trying to make is that, that this bill is a small bit of tinkering right at the end of this Act's lifespan. We're only 3 or 4 months away from the expiry of this Act. A lot of time has been spent debating this bill, taking it through the House. It is going to have an effect which will have obviously significant value for the people who will get the direct benefit of being covered by this bill. But we're talking about 70 claimants when there are some 42,000 homeowners around New Zealand who have been affected by this. And at a time when this government has ignored massive other problems with the building and construction industry.
Order.
Instead of this kind of superficial tinkering that doesn't even scratch the surface, we need a government that takes the issues and this vital industry much more seriously.
Scott Simpson.
Thank you, Mr. Speaker. As Chairman